Now, let's move on to employment discrimination based on sexual orientation. And I want to look at federal laws and state laws quickly. At this point, there's no federal law that prohibits employment discrimination based on sexual orientation by private employers. The EEOC has defined Title VII of the Civil Rights Act of 1964, which prohibits employers with 15 or more employees from discriminating in employment decisions on the basis of race, color, national origin, gender, or religion. The word gender has never been interpreted to mean sexual orientation, but the EEOC did so last year with respect to federal employees, not private employers, okay? So, and then you have the Employment Non-Discrimination Act, or ENDA, which has been submitted to most sessions of Congress now for about 20 years, that would ban discrimination in employment by private employers based on sexual orientation or sexual identity. That law has never passed, and it does contain a very broad exemption which says this: this act shall not apply to a corporation, association, educational institution, or society that is exempt from the religious discrimination provisions of Title VII of the Civil Rights Act of 1964. So again, even if that law is ever enacted, which I don't see that happening in the near future, it does have a broad religious exemption. Now, with regard to state laws, there's 21 states that have enacted statutes that prohibit employment discrimination by private employers on the basis of sexual orientation. None of these applies to churches. Why? For a couple of reasons. Number one, they have broad religious exemptions. And number two, many of these are amendments to more general employment discrimination laws that the state has enacted that are not triggered unless you have a specified number of employees, which typically is 5, 10, sometimes 15, and many churches are below that threshold level. But even apart from that, there are these broad exemptions for religious organization. Many of these laws ban discrimination on the basis of sexual orientation, not just in employment, but also in public accommodations and in housing. But again, the religious exemption applies. Some of these laws ban gender identity discrimination. We'll talk about that here in a minute. And many cities, I think it's well over 100, have city ordinances that prohibit employment discrimination by employers within the city on the basis of sexual orientation, in many cases sexual identity as well. So that's something to be aware of. I haven't done an exhaustive search of municipal ordinances, but you just want to, if you live in a larger city especially, that's something that might be worth checking out. And of course, we have the ministerial exception, which the United States Supreme Court recognized unanimously last year, which says that the civil courts are barred by the First Amendment guarantee of religious freedom from intervening or interfering with employment disputes between clergy and churches, ministers and churches. So that law, or that ruling, is very relevant here as well. So clergy who argue, I was not hired by this church because I'm gay, there's no way that case is going to be heard by any federal or state court because of the ministerial exception. Or I was terminated because I revealed my sexual identity. Or I was not hired because of my sexual orientation or sexual identity. I had a sex change operation. The ministerial exception is going to be a defense in all of these cases. Let me just conclude with one issue, Jerry, and then I want to ask you something. You've been kind of silent today.
Yeah, I have been.
And that is transgender discrimination. Do you know that 16 states plus the District of Columbia prohibit employment discrimination by private employers on the basis of sexual identity? As I said, ENDA covers it, the Employment Non-Discrimination Act, which has never been adopted yet. But keep in mind that these non-discrimination laws focus on employees, not volunteers, not members. Many churches have contacted me about this. We have a man that became a woman because of a sex change operation. Can she use the women's restroom? Did she have to go on women's trips out of town and sleep in the same bed with another woman, or with a woman? Boy, the questions I get. And I just refer them to Jerry. And so the point is, they're not employees, so they're not covered by these laws. They're members, and the courts have consistently ruled that churches have a right to define their own membership. Now, Jerry, here's the question. So we've talked about a number of potential theories of liability. Churches may get sued because they are perceived as discriminating on the basis of sexual orientation in employment decisions. Even though they may be exempt, you may have to defend yourself, and that can be costly. So a question that often arises is, does the church liability policy cover employment practices?
And actually, that's a great question. Most directors and officers liability, if you have directors and officers liability, there's an endorsement you could add in to that for employment practices liability. And whether you have 1 or 2 employees, it is good to have minimal coverages. It is very inexpensive to have employment practices liability. And the majority of the cost normally, as you mentioned, really comes from defense cost. And so actually I would suggest, as far as an insurance program is concerned, that they have not only directors and officers liability, but they go ahead and throw in the endorsement for employment practices liability.
And Jerry, let me add something here. My research of reading every case decided in this country pertaining to religious organizations for the last several years has shown employment liability, number 3 of all categories of liability. And so this is a very real concern for churches. And oftentimes they get sued for some employment-related dispute, discrimination, wrongful discharge, and they come to find out they get a no coverage letter. That's not covered under your insurance policy. They're shocked.
Yeah. It is an amazing thing. Probably 5 years ago, we would have never heard about employment practices liability or people suing their employer for wrongful termination. But as you said, in the last few years, people are willing to sue the church now and to sue religious organizations. Whether you sue a pastor because I'm suing this church because I was too old and they brought in a younger pastor, or they wouldn't hire a female pastor and they have a male pastor. We're starting to see race discrimination, age discrimination,
disability,
sex discrimination, disability discrimination. One of the things that we also see now is moral discrimination. You want to talk about that?
Yeah, well, the issue there, of course, is a church that terminates a 19-year-old female in the church preschool for being pregnant out of wedlock. But come to find out, 5 years ago, he had a youth pastor, male, that engaged in extramarital sexual relations, and he was just, disciplined but retained as an employee. The courts have said this loudly and clearly in recent years. Churches, you are free to impose your moral codes on your workers, but you must do so consistently and uniformly in a way that doesn't adversely affect a protected group, such as females, people over 40, disabled, etc. And so with a vengeance, you will see churches that are sued for enforcing their employment standards, and come to find out, you're going to be you're going to be compelled to prove that you have not acted discriminatorily in enforcing your biblical standards.
What's interesting is that moral discrimination really is not covered under employment practices liability, but as you said, you're not treating the males as you would treat the females, and you get into then sex discrimination. So, wow, tough topics.
So, Jerry, but the point is, employment practices is not covered under the standard liability policy.
Absolutely
So how
not.
does a church get it?
They need to add that endorsement to their policy. They need to have directors and officers liability and employment practices liability, and they need to add that to their policy.
I would agree.
So, we're out of time again. One question, I'm going to ask you one little question here. If a church has a for-profit center, let's say a bookstore or a cafe, that is for-profit because they can't qualify for nonprofit and they're selling items, would that affect them because they now have a for-profit section versus a nonprofit? Has there been any case law on this so far?
I can't remember seeing a case on that, but I'll tell you, I think there's a strong case to be made that if this practice, a coffee shop or bookstore or whatever, has moved itself intentionally out from under the organizational umbrella of the church and has become a standalone for-profit corporation, I am not confident that the religious exemptions available to the church are going to carry over to that organization.
So as long as it is just as part of the mother company and comes under their umbrella still, it should be fine.
Well, it should be, but again, it's fact intensive. It'll be based on the facts of each case, and it's hard to make generalizations.
Yeah, well, and in today's society, things change, as we have seen with everything else. So it depends on the court cases and the interpretations also. Well, we appreciate your time, and thank you for joining Risk Management Live. We'll see you next month. Thank you very much.